On Wednesday, Arkansas Attorney General Tim Griffin asked the Arkansas Supreme Court to lift a lower court decision ruling blocking the implementation of the LEARNS Act. Here to break it all down for us is UALR Bowen School of Law professor Robert Steinbuch, and of course, he is here representing his own ideas and beliefs. Hi, thanks for joining us.
Great to be back with you, Ginny.
Absolutely. Well, listen, a Pulaski County Circuit judge on Friday issued a temporary restraining order against Governor Sanders' LEARNS Act. Of course, as we all know, this was her signature piece of legislation, a really big deal to allow school choice to happen for all kids here in Arkansas, but now it's been put on hold. Of course, Attorney General Tim Griffin responded within hours. Catch us up to speed, and what does this all mean for those who are trying to put the pieces together?
Yeah, it's interesting but technical. So when you pass a bill, if you just pass the bill, you need 50% of the vote of each chamber. Of course, we know that from our Saturday morning cartoons, amongst other things. In Arkansas, you can also pass what's called an emergency clause that accelerates when the bill becomes a law. Usually, you have to wait for the law to become effective 90 days after, excuse me, the session ends. Yeah. And if you put an emergency clause, it kicks in essentially immediately.
Right.
So to be clear, we're talking about a difference of roughly 3 months. It's not a huge difference, but it's something. So the LEARNS Act was passed with an emergency clause. The Arkansas Constitution says if you, and to be clear, to pass an emergency clause, you need a 2/3 vote, not just a bare majority. The Arkansas Constitution further says that you need separate votes. Well, the practice that has been in existence for decades, if not even longer than that, meaning like a century plus, is that when they take a vote in the Senate or the House, they take one vote, meaning they put the bill up on the board and they count up all the votes. And if there's an emergency clause in that, they record that number separately from the number for just passing the bill, because we need to reach different thresholds after all. And if you don't meet the threshold for the emergency clause, it's recorded as failing on the emergency clause. And if it passes on the general bill, it passes without the emergency clause, and those are recorded separately. This seemingly has never been objected to in this form before, but now there, of course, has been a lawsuit filed saying, no, you needed, when the Constitution says separate votes, you needed to say all in favor of the bill, and then the names go up, all in favor of the emergency clause separately, and then the names go up. That's certainly one interpretation, meaning it's not as if you couldn't read it that way, but it hasn't been read that way. And when we're dealing with constitutional interpretation, whereby the possibility of striking a law exists, two things are important. One is we need to be narrow to interfere with the democratic process. And two, history is a factor. A factor, not the factor, but how it's been interpreted all along gives us some information into what those words mean and meant at the time it was drafted, in fact. So with all of that, I think the better argument is indeed the one of the governor and the attorney general. And you know me, I'll tell you if they were wrong. I have at least one, I think maybe 2 lawsuits in which the attorney general is on the other side. So I'm not shy to say that they're wrong when they're wrong. To be fair, I don't think that the whole argument is ridiculous, but I think the better argument is had by the governor. Moreover, in the end, what's going to happen? If they strike the emergency clause, well, then they still have the law. The law passed. So that means, so it means 3 months later, the law gets implemented. It's not ideal for those that want to implement it earlier, and I don't know all the mechanics, needless to say, anything close to that. I suspect that they want those 3 months very much. But in the end of the day, okay. So it's, and then there's, of course, a third option. And that third option is the governor can always call a special session. So she could call a special session for tomorrow and then have a new vote following this purported procedure just to be safe.
Yeah.
And then
That would mix it up, wouldn't it?
it really would. And frankly, I would enjoy seeing that because I think it would be interesting and a good way to rebut those that are trying to kill what is a very good law. I don't know every detail about it, to be fair, but I will tell you that generally, the notion of giving parents choice, a friend of mine, just the other day in Conway, his daughter was ill. And so he called the school and said, yeah, my daughter can't come in because she's ill. And they said, well, that's not going to be an excused absence. And if you have more than 10 or something, you have to pay a fine and some like ridiculous draconian punishment, no less. And he said, well, why is sickness not an excused absence? And they said, oh, sickness is, but you need a doctor's note. So you tell me as a parent that I need to prove to you that my child is sick? You don't think I know when my child is sick? So this is where we see this example of the administrative state believing that it determines how we run our lives.
Absolutely.
Right? It takes a village was the beginning of this notion, Ginny. It takes a village was the village is government. The village is not your family. The village is government. And it takes a government to raise your family, says the left. Well,
I wanted to read. Well, I wanted to read a statement one of the statements that Governor Sanders put out yesterday to go along with the point that you're making now. And she said, by playing politics with our kids' future, the radical left is halting teacher pay raises, school safety trainings, literacy coach hiring, and our new maternity leave program, sowing unnecessary turmoil in schools. And so one would have to wonder and ask, why are those opponents so hell-bent on keeping families from being able to choose the best school for their kid?
Well, I think the answer is clear.
Yeah.
Because they want to make the choice. You see, this is the mindset of the left. The mindset of the left is we know better than you. So why would we listen to you when we know better than you? Says them, to be clear. Look, I work in academia. It's overwhelmingly leftist. Yeah. And I've never seen in any other environment in which I've worked or been otherwise, in which people were so sure of their knowledge about everything when presented with the choice of them making a decision or letting individuals make decisions about their own lives. And it's absolutely tragic. And of course, history is just laden with example upon example of when government knew better, right? Famine, starvation, poverty, all because of government action. So, the Hippocratic Oath in medicine is first, do no harm. And government has done so much harm. We well know President Reagan's statement along the lines of, be afraid of the following words when they show up at your door, when government shows up at your door, we're here to help. Be very afraid of that.
Yeah, and I do think that voters are more awake to that idea. But going back to the Learns lawsuit, Griffin, state officials, they say that delaying the law, so go back to the emergency clause, that delaying this will put a strain on districts and hurt students. And, having worked in administration of public school system, these summer months are really crucial in admin regarding, and like what the governor mentioned in her tweet regarding teacher contracts, certified, classified staff. Saying, well, if this lawsuit were to hold up, okay, what's 90 days from, sine die? Well, but that's still, if you're a public school system and you're planning going into August, those are some crucial weeks there. But I just find it really interesting that, again, this lawsuit is not on the merits of Learns. It is just strictly about how they took the vote.
Yeah, well, but it can't be on the merits. They don't. Yeah, they're chumming the waters, right? And there's nothing to do regarding the merits. Bill passed. They don't like it. They didn't have enough votes to stop it. So that's the end of that. There's nothing unconstitutional about it. So they've got to come after it procedurally, if at all. And, we'll see what happens. I think, as I mentioned, the governor has a good argument here.
Yeah. So let's say that the plaintiffs were to win this case regarding the emergency clause. In your opinion, how could that affect recent legislation passed, whether it be appropriation bills that includes funding? What would that look like?
Right. So presumably this has happened for other laws that passed this past session, meaning I presume there are several laws that passed with emergency clauses. And if the Supreme Court were to say that's what the way they've been doing it for years and years is not the proper way, then would have to undo a bunch of laws. And my guess would be indeed that the governor would call a special session. As I think I mentioned already earlier in this conversation, I think it'd be great for her to call a special session now. Now, to be clear, I'm going to get phone calls after this video airs from various legislators saying, Rob, we're done. We don't want to come back. So you guys figure it out. You lawyers go figure it out.
Yeah.
But I like to see the government at work. So I think it would be fun if they called them back.
Yeah, that would definitely, that would be wild. So hopefully the Arkansas Supreme Court will rule in this soon, possibly even by Friday, Monday. What do you expect to see?
I do think that the Supreme Court will rule in favor of the governor. That's my guess. But to be clear, it's just a guess. A lot of times, all these news shows, including yours, aptly ask lawyers and law professors what their opinion is. But ultimately, it's not what the law is. It's what do we think these 7 individuals on our state Supreme Court will say the law is. And my guess is that they'll side with the governor because I really do. That's the better interpretation of what the clause means. But at the end of the day, I've kind of stopped trying to be too exacting in my predictions of what judges will do because they're individuals. Here in Pulaski County, I'm very good at predicting what judges will do because they're all a bunch of liberals. And if the case has any political component whatsoever, they will come up with a conclusion that is entirely leftist, not because that's what the law says, because that's what they want it to say. We see that on the gun cases that I am handling. We see that on plenty of other cases. In fact, one judge, Chip Welch, cited to some 1950s TV show as a basis for denying one of our gun cases. And it seemingly believing that that's somehow a proper citation for law. Of course, make-believe, right? It's both literally make-believe, that's what television is, and its application in a legal opinion is make-believe as well. So I'm really good at predicting the outcome of political cases in Pulaski County. And I easily predicted that the Learns Act in Pulaski County was going to be struck as well. Not because it should have been.
Probably why they filed it there.
Yeah, although it's typically when you file against the legislature, you file in Pulaski County also.
Yeah.
So,
yeah.
But it's that was easy to predict because that's all these judges do. Every judge on the circuit court in Pulaski County is a Democrat, is a liberal, and everyone that I've seen, and I'd have to go through the list, but it's a long list that I've seen, when presented with a political issue, votes the politics, not the law.
One other thing that I want to ask you about is just about this Learns lawsuit and the procedural issue of it. And I know this is politics, right? This is what happens. But does it seem hypocritical at all that this is a practice that has been going on for a very long time on both Democrat and Republican issues, on Democrat-Republican bills, and there's never been a problem until the Democrats decide, you know what, we could maybe throw this at the wall and this one might stick. It just seems really hypocritical to me. And I've even seen on Twitter, as I'm sure you have, Democrats are saying, and even past legislators are saying, you know what, this is how it's been done for a very long time.
Yeah, well, I think as a technical matter, that's entirely correct. It is hypocritical that you're raising a practice that you've employed. But with that said, if you were in the legislature and you passed a bill, and even if you knew that the process wasn't right, you're not going to file a lawsuit against it because you think the bill's okay.
Right.
So yes, it's hypocritical, but with that said, if the Republicans wanted to object, they could have objected. Now, of course, Republicans think the process is fine. So, yeah, there's some hypocrisy.
Yeah.
Welcome to politics.
Yeah, I know. Well, anything else that you want to add before we let you go?
No, I just look. I think that it's going to be interesting to see what the Supreme Court says. I think an important sort of meta issue that this applies to, or that this is useful for analyzing, is we need to return to partisan elections for judges. Now, some people say, well, partisan's kind of a bad word, isn't it? No, partisan simply means when you run for office, you see the political party, right?
Yeah.
The president runs as a Democrat or Republican, or another party, but typically, right, that's not viable. But judges don't get to list their party. And it's kind of silly because at the Supreme Court level, amongst other places, we have judges who are kind of hidden leftists. I was very impressed, for example, when Barbara Webb ran for the Supreme Court fairly recently, and she said, well, I'm a conservative. Some people say, well, you can't say that.
Right.
These are nonpartisan.
Yeah.
She said, it's not a conservative party. I'm a Republican in terms of parties. I'm a conservative in terms of philosophy. That's a political belief system. And to be clear, also a judicial belief system. They overlap, but they're not the same. So she said, I'm of course allowed to say I'm a conservative the same way she's entitled to say she's a Christian after all, right?
Right.
So it was rather funny to see people become apoplectic. And I'm so glad she stood by her God-given rights and her First Amendment rights to declare both her political and judicial philosophy. And I found that very, very impressive. So we need to, but we do need to return to voting for judges with party identification.
Hey, I like that idea. I really do. Robert, thank you so much for joining us on Conduit again soon. Hope that you come back.
I'm going to do it. See you soon.